Mr. Binger is either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an experienced attorney, and he knows better.
Mr. Binger?
First of all, Your Honor, this was the subject of a motion. I'm well aware of that, and the court left the door open.
For me, not for you.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was on our
Excuse me, I did. I granted.
We did not move
that
to
was their
reconsider.
motion.
We have not filed
forgive
any
me.
motions to reconsider in
Forgive
this
me.
case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed another acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect,
I'm not going to rehash the motion. That's absolutely untrue.
It
No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest that anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
Your Honor, there have been things in this case, testimony in this case, that I believe opens the door to this. For example, the defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car on the car source lot. Now, there's no justification that I can think of why the defendant would point that gun at someone. The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car.
He said, I didn't. That's what he
Exactly.
testified.
So he's agreeing. May I finish, please? I'd like to have a chance to make a record if I could, without being interrupted, if that's okay. He has mentioned that he's acknowledged that he's used this gun to protect property. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now with the prior August 10th incident, 15 days prior, involving the same gun, where he is threatening to use that gun to protect property.
He didn't have the gun with him.
Your Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense theory of the case is.
May I respond to what you just said, Your Honor? I'd like to respond to what you just said.
Slow down, please.
I apologize, Madam Court Reporter, but I'd like to try and make a record without anyone interrupting me, if that's okay. I believe that there is a central part of this case that Mr. Rosenbaum is making threats that he has no ability to carry out. So